Hello, everyone, and welcome to Uncivil Law. If you don't have a stiff drink, I recommend getting one. I do. Today's concoction is Eagle Rare, very nice, mixed with generic ginger ale. Nothing special there because, finding supplies is a little bit troubling right now, and I've got the bottles right next to me. I've got my first glass in the glass. Probably will not be my last. This is the United States Supreme Court case of Kansas v. Glover. You may remember this case. We did it as a live stream react some time ago on one of our Scottish React streams on Friday. We heard wonderful argument from Sarah Harrington, who I declared to be the love of my life, who gave an outstanding, wonderful oral argument, which I thought was so brain dead simple, it was going to win the day. I think I officially predicted 6-3 was my official prediction for Glover to win. But no, it was 8-1. It was 8-1 for Kansas. So, we're going to try to figure out why, guys. But first, I want to remind you guys of the facts of the case and the issue of the case. For those of you who did not see our previous live stream and don't know what we're talking about, I'm sure the court opinion will cover a lot of this again, but let me read you the facts of the case as it was summarized by the website OYE. So this is what they say happened. The facts of the case. While on patrol, a Kansas police officer ran a registration check on a pickup truck with Kansas license plates. Upon running the check, the officer learned that the truck was registered to Charles Glover and that his license had been revoked. Acting on suspicion that the owner was unlawfully operating the vehicle based on the assumption that the registered owner of the truck was also the driver, the officer stopped the truck. The officer confirmed that Glover was the driver and issued him a citation for being a violator of the relevant law. Mr. Glover moved to suppress all evidence from the stop, arguing the stop violated his Fourth Amendment right against unreasonable search and seizure. According to Glover, the police officer lacked reasonable suspicion to pull him over. The state argued that the law enforcement officer may infer that the owner of the vehicle is the one driving the vehicle, absent information to the contrary. And knowledge that the owner has a revoked license combined with that inference gives rise to reasonable suspicion to conduct an investigation stop. The state trial court concluded it was not reasonable for the officer to infer the owner was also the driver and granted the motion to suppress. Glover won at trial. The appellate court reversed, and the Kansas Supreme Court granted review. The Supreme Court of Kansas held that the inference impermissibly stacked assumptions and would relieve the state of its burden of showing a reasonable suspicion for the stop. Thus, the question presented. For the purpose of an investigative stop under the Fourth Amendment, is it reasonable for an officer to suspect that the registered owner of a vehicle is the one driving the vehicle, absent any information to the contrary? Yeah. So, just so I can recondense that into a shorter form, the officer saw a truck. He ran the plates. He knew the owner had a suspended driver's license. He didn't know who was driving, but he knew the owner had suspended license. Based on that and nothing more, he pulled over the driver. The question is it legal or not? Spoiler alert, it's legal. Yeah. So let's read this and try to figure out why. So in case you're wondering what's above what you're reading on screen, above this is just the syllabus. It's the summary of the case. We're not going to do any stinking summary. So we don't need to read the same thing twice, right? The summary is just prepared by the court for the convenience of the reader. We don't need any convenience. So we're not going to read the syllabus because we're about to read it in full. But we might as well see the vote counts. Thomas delivered the opinion of the court in which everyone joined. Kagan filed a concurring. Ginsburg filed a concurring. And Sotomayor, who during the Supreme Court react, said, Sotomayor was the only one with a brain today on the entire damn Supreme Court, was an exact quote I said during that straight. Sotomayor is the only one with a damn brain today on the entire Supreme Court. Was the only one dissent. 8-1, Kansas wins. Let's find out why. Let's find out why. Justice Thomas delivers the opinion of the court. This case presents the question whether a police officer violates the Fourth Amendment by initiating an investigative stop after running the vehicle license plates and learning that the registered owner has a revoked driver's license. We hold that when an officer lacks information negating an inference, the stop is reasonable. Okay, I guess. Kansas charged respondent Glover with driving as a habitual violator after a traffic stop revealed that he was driving with a revoked license. Glover filed a motion to suppress all evidence during the stop, claiming that neither the officer did not have suspicion. Neither Glover nor the police officer testified at the suppression hearing. Instead, the parties stipulated to the following facts. So no one testified, we just stipulated the facts. So here are the facts. Deputy Mark Meyer is a certified law enforcement officer in the Douglas County Sheriff's Office. On April 28, 2016, Deputy Meyer was on a routine patrol in Douglas County when he observed a 1995 Chevrolet 1500 pickup truck with Kansas plate 295 ATJ. Deputy Meyer ran the plate through the Kansas Department of Revenue File Service. The registration came back to the 1995 Chevrolet pickup truck. The Kansas Department of Revenue files indicate the truck was registered to Charles Glover. The files also indicate that Glover had a revoked driver's license in the state of Kansas. Deputy Meyer assumed the registered owner of the truck was also the driver. This is the part where I dump out the analysis, but apparently not for the Supreme Court. Yeah. Deputy Meyer did not observe any traffic infraction. If he had observed a traffic infraction, he'd be fine. He didn't observe any traffic infraction. And he didn't attempt to identify the driver of the truck. Based solely on the information the registered owner of the truck was revoked, not knowing who was driving, Deputy Meyer initiated a stop. Not because of a traffic violation, not because they knew who was driving, but based on an inference or something. I don't know. The driver of the truck was identified as the defendant Glover. The district court granted Glover's motion to suppress. The Court of Appeals reversed, holding it was reasonable for Meyer to infer the driver was the officer, owner of the vehicle, because there was specific articulable facts from which an officer's common sense inference gave rise to reasonable suspicion. I don't know how without more you conclude that you can just infer the owner is the one who's driving. I don't know, but apparently this is possible. The Kansas Supreme Court reversed. According to the court, Deputy Meyer did not have reasonable suspicion because his inference he was behind the wheel amounted only to a hunch that Glover was engaging in the criminal activity. The court further explained that Deputy Meyer's hunch involved applying and stacking unstated assumptions that are unreasonable without further factual basis, namely, the registered owner was likely the primary driver, and the owner will likely disregard the suspension or revocation order. We grant cert and we reverse. Okay, good times. Under the court's precedents, the Fourth Amendment permits an officer to initiate a brief investigative stop when he has particularized an objective basis for suspecting the particular person stopped of criminal activity. And that would be fine. Citing Terry. We all remember Terry, right? Although a mere hunch does not create reasonable suspicion, apparently it does, The level of suspicion the standard requires is considerably less than proof of wrongdoing by preponderance of evidence, and obviously less than needed for probable cause. Because it can be less demanding, reasonable suspicion can be established with information that's different in quantity or content than that required to establish probable cause, which I don't object to. It's a lower standard, so obviously we need less of it, right? Now, okay, the standard depends on the factual and practical considerations of everyday life and what a reasonable and prudent man, the ordinary careful observer, not legal technicians, act. Courts cannot reasonably demand scientific certainty where none exists. Rather, they must permit officers to make common sense judgments and inferences about human behavior. We have previously recognized that states have vital interest in ensuring that not only those qualified to do so are permitted to operate motor vehicles, and that licensing, registration, and vehicle inspection requirements are being observed. With this in mind, we turn to the facts known to Meyer at the time. As to whether or not they gave rise to reasonable suspicion, we conclude they did, somehow. Before initiating the stop, Meyer observed some individual, of some description. We don't know what this individual looks like. We don't know if it's a man or a woman. We don't know if it's black or white. We know nothing. We see someone driving a car. Okay, he also knew the registered owner had a revoked license and the model of the truck matched that of the observed vehicle. So the plates matched the car they were supposed to be on, which is like, what you need to, good stuff. From these three facts, Meyer drew the common sense inference that Glover was likely a driver, which proved more than reasonable suspicion to initiate the stop. Really? More than reasonable suspicion. Okay. The fact that the registered owner of the vehicle is not always the driver does not negate the reasonableness of the inference. Such is the case with all reasonable inferences. The reasonable suspicion inquiry falls considerably short of 51% accuracy. Right, because that would be like preponderance, more likely than not. For as to explain, to be reasonable is not to be perfect. Okay. Glover's revoked license does not render Meyer's inference unreasonable either. Empirical studies demonstrate what common sense readily reveals. Drivers with revoked licenses frequently continue to drive and therefore pose safety risks to other motorists. Okay. Apparently noting that 75% of drivers with a suspended or license continue to drive. Okay. Approximately 19% of motor vehicle fatalities involve drivers with invalid licenses. All right. Although common sense suffices to justify the inference, Kansas law reinforces that it's reasonable to infer that an individual with a revoked license may continue driving. The state's license revocation scheme covers drivers who have already demonstrated disregard for the law or are categorically unfit to drive. The Division of Vehicles of Kansas's Department of Revenue shall revoke a driver's license upon certain convictions. Reckless driving is defined as driving any vehicle in wanton care. The division also has discretion to revoke a license if he's been convicted with offenses, blah, 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 blah. Other reasons include other things. So we have a bunch of reasons we can revoke someone's license. At this particular moment in kind, I don't think that the reasons why the license was suspended, I don't really care. That's not the operative issue. Sorry to interrupt your reading. What's your opinion on the COVID-19 cover-up with 5G? 5G did not cause COVID or have anything to do with COVID in any way whatsoever. That's my opinion. Leonard says he had a guy on his 22nd while driving while suspended charge. Apparently he didn't learn the first 21 times, Leonard. I don't know, man. First, Glover and the dissent argue that Meyer's inference was unreasonable because it was not grounded in any training or experience. Nothing in our Fourth Amendment precedent supports a notion that, in determining whether reasonable suspicion exists, an officer can draw information based on knowledge gained only through training and experience. We have repeatedly recognized the opposite. In a prior case, we noted a number of behaviors, including driving in a median, crossing the center line, and swerving, were sound indicia of drunk driving. They certainly sound that way, right? Hey, tell that story sometime. That sounds good. In Wardlow, we make the unremarkable observation that a headlong flight, whatever it occurs, is a consummate act of evasion, and therefore could factor in a police officer's reasonable suspicion. Two Euro, I believe it is, from Augusto P. Judge Judy for Scottus. You know, I'm people probably know this, or maybe they don't, but Judge Judy, otherwise known as Judith Scheinlin, was a 25-year veteran of family courts of New York before she ever became a TV judge. So, you know, we could do worse than Judge Scheinlin on the Supreme Court. The dissent reads our case differently, contending that they permit an officer to only use common sense derived from experiences in law enforcement. Such a standard defies common sense understanding of common sense. Okay, that's one hell of a sentence. Such a standard defies the common sense understanding of common sense. Okay. That would be information is accessible to people generally, not just some special subset. More importantly, this standard appears nowhere in our precedent. In fact, we state a reasonable suspicion is an abstract concept that cannot be reduced to a neat set of legal rules, and we repeatedly rejected courts' effort to impose a rigid structure on the concept of reasonableness. How about something based on anything that's rooted in some sort of reality? The dissents rule, written by apparently the only coherent judge for some reason, the dissents rule would also impose on the police the burden of pointing to specific training or field experiences justifying reasonable suspicion for a myriad of infractions in the municipal codes. And removing common sense as sort of evidence, the dissent would considerably narrow the daylight between showing required for probable cause and the less stringent showed for reasonable suspicion. I still don't understand why it's reasonable. Like you know the truck is being driven, and you know the owner has a suspended license, but what's the basis to assume the owner is the one driving? And like, you know, especially in a lot of poor families, you know, where car sharing would probably be more common, right? So this means that like if, you know, one member of the fat household gets their driver's license suspended, they own the car, it's impossible for any other member of the car or any other member of the family to drive the car without being pulled over, right? It's impossible to do that now. So you better not rent a car from someone who has a suspended license, I guess. In reaching this conclusion, we no way minimize the significant role that specialized training and experience routinely play. We simply hold that such experience is not required in every instance. I don't necessarily disagree with that. I just don't know how we can get to anywhere we want to be. Glover and the dissent also contend that adopting Kansas's view would eviscerate the need for officers to base reasonable suspicion on specific and articulable facts. That's what I thought. Particularly needed to the individual, because police could instead rely on exclusively on probability. Their argument carries little force. Excuse me. As an initial matter, we have previously stated an officer, like jurors, may rely on probabilities and reasonable suspicion. Moreover, as explained above, Deputy Meyer did not rely exclusively on probability. Like, he kind of did. Yeah, he knew the license plate was linked to a trunk, matching the vehicle owner, and the registered owner had it revoked. Based on these minimal facts, he used common sense to form a reasonable suspicion. You're saying this like it's true, but how do those two things go together? Based on these minimal facts, he used common sense to form a suspicion. Why is it a reasoned suspicion? That would be what the word reasonable typically means, right? Reasoned, using reason, reasonable, right? Specific individual was potentially engaging in criminal activity, driving with a revoked license. Traffic stop of this nature do not delegate officers broad and unlimited discretion to stop officers drive people at random. That's nor do they allow officers to stop drivers whose conduct is no different from other drivers. Accordingly, combining database information and common sense judgment is fully consistent with the court's Fourth Amendment precedent. Okay, for somehow. All right, that makes sense. Yeah. This court precedent have repeatedly affirmed the ultimate touchstone of the Fourth Amendment is reasonableness. Under totality of the circumstances, Meyer drew an entirely reasonable inference that Glover was driving while his license was revoked. We emphasize the narrow scope of our holding. I don't think it's that narrow. I mean, by this logic, anyone who owns a car and their driver's license is suspended, that means they can't rent. They can't give it out to any other member of anyone else in the family. So, or lend it to anyone else without that person being stopped for just borrowing a car from someone else. You know? Like all seizures, the officer's actions must be justified at inception. The standard takes into account the totality of circumstances, the whole picture. As a result, the presence of additional facts might dispel the reasonable suspicion. For example, if the officer knows the registered owner of the vehicle is in mid-60s, but observed the officers in mid-20s, the totality of circumstances would not raise a suspicion. Well, geez, what does that tell an officer not to do? What does that tell an officer not to do? That tells an officer not to look, right? Right? Because you might gain more facts that would dispel the suspicion. And a lot of cop cars now have cameras, and these cameras do automatic license screening as they're going by the road, right? They automatically scan any plate that looks by. So, here's the scenario going forward. And it's a very likely scenario going forward, right? The cop car automatically scans the plates of any car it sees. It automatically runs a check behind the scenes, right? And then, as the cop is driving around, not particularly paying attention to anything in particular, I'm sure he's paying attention to the road, but he's not otherwise paying attention to anything in particular. The car alerts him. He gets a little notice. It says, hey, this car is owned by someone who has no driver's license suspended. Now, what is in the officer's interest at that exact moment? To just immediately turn on the blues and twos. To just turn on the lights and sirens. Why look? Why even glance up at all from the screen that's now alerting you and look up? Because you might accidentally see the person and now you can't pull them over. Why would you do that? So the officer's incentive now is to not pay attention because I never saw the person. The car just alerted me and I pulled them over immediately. I had no idea who was driving. Of course I didn't look. I did an immediate stop. Okay. Deputy Meyer possessed no exculpatory information, and presumably no deputy ever will ever again, let alone sufficient information to rebut reasonable inference that Glover was driving his own truck and thus the stop was justified. For the foregoing reasons, we reverse judgment of the Kansas Supreme Court and remand this case for further proceedings not inconsistent with this opinion, which presumably means Kansas assumes Glover's getting whatever sanction he'd get at trial. Because we know it was him driving now, so I don't know what the penalty that he's getting is, but presumably that's what's happening now. I'm going to make myself another drink, and then we're going to read the dissent. So it was only a 10-page opinion. It was only 9 pages, really, because, but. So in the future, all the cops, if they don't already, will have cameras fitted to their cars. It will automatically scan all the plates of cars that come by. And it will pop up and say, owned by someone who has a suspended license, and they'll be able to pull that over and do a full stop on just that basis alone. And I would expect this is most likely to impact the poor, who are most likely to not have as many cars and most likely to have to share cars, and so forth and so on. So that's concerning. So that is concerning. Okay. And then, of course, lest I have to point out these things, but I will anyway, once the officer has pulled you over and has asked for your driver's license, they can say, hey, I smell marijuana, and conduct a more search. So it's like, it's a whole thing. All right, let's read what Justice Sotomayor, I consider myself a conservative-leaning guy. I consider myself a right-wing guy, but apparently for some we're not quite to Sotomayor. We're on some of the concurring opinions. I'm not 100% surprised Kagan went this way, but we'll read the whole thing. But apparently, somehow today, it's me and Sotomayor that are on a team together. I'm not sure, but okay. All right, let's read what Justice Kagan and Ginsburg has to say. So all you people out there who are big Justice Ginsburg fans, let's see how Justice Ginsburg wants to screw you all today. How does Miss ACLU herself want to rule on this? When you see a car coming down the street, your common sense tells you the registered owner may well be behind the wheel. Not always, of course. Families share cars. Friends borrow them. Still, a person often buys a vehicle to drive it himself. So your reasonable suspicion that the person owner of the driving would be reasonable. Now, though, consider a wrinkle. Suppose you knew the registered owner of the vehicle no longer had a valid license. That add fact raises a question. What are the odds that someone who's lost his license would continue to drive? The answer is by no means obvious. You might think a person told not to drive on pain of criminal penalty would obey the order, so that if his car was on the road, someone else, a family member or a friend, must be the one doing the driving. Or you might have the opposite intuition, that a person's reasons for driving would overcome his worries about violating the law, no matter the possible punishment. But most likely, let's be honest, you just wouldn't know. Especially if you've not had your own license taken away. Your everyday experience has given you little basis to assess the probability. Your common sense can therefore no longer guide you. So common sense is not available. So Kagan, wow. So Kagan and Ginsburg are if anything going further than Thomas. They're going further than Thomas because they're saying he didn't even have the reasonable inference, right? So they're even taking that element away. So apparently Kagan and Ginsburg are more right-leaning than Justice Thomas. I'm going to let you contemplate that as I drink this some more. Yep. Yeah. Okay. Apparently, Kagan and Ginsburg are more right-leaning than Justice Thomas. Justice Thomas said, well, at least they had a reasonable inference. And Kagan and Ginsburg said they didn't even have that. But it's totally okay. Okay. Even so, even without common sense, Mark Meyer had reasonable suspicion, despite the lack of common sense. That one hurts my brain. Guys. That one hurts my brain. Your common sense can therefore no longer guide you, but even though you don't have common sense, you can still have reasonable suspicion. So even though you don't have common sense, you still can reason suspicion, even in the face of lack of common sense, which is not available to you. And it's okay for the state to pull people over. Did Ginsburg join a right-wing organization while I wasn't paying attention or something? This is okay. Well, all right. And I joined the holding as much. That's good news. All right. Crucially for me, Meyer knew yet one more thing. Crucially for me, Meyer knew yet one more thing about the owner, and related to a proclivity for breaking laws. As the court recounts, Meyer learned from the state database that Glover, the owner, has license revoked, and Kansas almost never revokes license except for serious repeated offenses. Crimes like whatever are grounds to revoke. In other words, a person with a revoked license has almost always shown a willingness to flout driving regulations. That fact, as the court states, provides reason to infer that such a person will drive without a license, at least as often enough to warrant an investigative stop of whoever happens to be driving. There's nothing else here to call the inference in question because the officer didn't look, nor will they ever again. That's because the party's unusually austere stipulation confined the case to the facts stated above, which I thought was going to be fatal to the state's case, but somehow not so much. But as Ari suggested, I would find this a different case if Kansas had barred Glover from driving on a ground that provided no similar evidence of penchant for ignoring driving laws. Consider, for example, Kansas has suspended rather than revoked the license. Along with many other states, can't suspend license for matters having nothing to do with safety. Indeed, several studies have found that most license suspensions do not relate to driving at all, whereas they relate to being poor. So good reason to give the court for thinking that someone with a revoked license will keep driving, that as history disregarding rules will no longer apply. She's trying to come back at it by saying if you've had your license revoked, that's one thing, but not if it's been suspended. But like that's not the majority decision, so like whatever. Oh no, this decision's nationwide, Maladrom. No, this sets precedent nationwide. So every state is completely free to rely on this decision fully. So, if the good old boys at Alabama weren't already pulling over everyone with a suspended license, they can do so starting tomorrow. Nothing stopping them. Supreme Court rules on it. It's nationwide law. It would have to rest on the idea that frequency with which even those had completed driving laws would defy state penalty. Where would the idea come from? As discussed above, I doubt whether our collective common sense could do necessary work. Or as otherwise said, I suspect any common sense invoked in this altered context would not much differ from a mere hunch, and so would not create a reasonable suspicion. I don't follow that one bit. Even when, as under revocation scheme, as in here, a starting presumption of reasonable suspicion makes sense. How does it make sense in a revocation scheme, but not in a suspension scheme? I don't know. Jan is correct. Jan is absolutely correct. The Fourth Amendment sets a floor, not a ceiling, so the Kansas Supreme Court remains free to interpret its own state constitution to forbid this stop if it so chooses. So Jan is correct. The Kansas Supreme Court can yet save Mr. Glover by saying, well, it's not a violation of the federal Fourth Amendment because it's not, but it is a violation of our state constitution. So Jan is correct. There is a saving grace there. Assuming there's a Fourth Amendment equivalent of the Kansas state constitution, and assuming the Kansas Supreme Court wants to do that. It is an option available to them. Jan is correct. But as I was alluding to, Kansas doesn't have to, nor does any other state. So once again, if the Friends of Alabama wants to start pulling people over tomorrow, that is their prerogative. And even when, as a revocation scheme here, a starting presumption of reasonable suspicion makes sense, the defendant may show that in his case, additional information dictates the opposite result. The court is clear on this point, emphasizing that on the applicable totality of circumstances, the presence of additional facts might dispel suspicion. What additional facts will there ever be? All officers are going to do are just say, oh, the car told me that it was, and I immediately put on my lights and sirens. What additional facts will there ever be ever again? Just as the court once said of a trained dog detection dog alert, the license revocation signal is also always subject to defendant's challenge, whether through cross-examination or introduction of own factor witnesses. This challenge may take any number of forms. The court offers a clear example of observational evidence dispelling reasonable suspicion. If an officer knew that the owner was an elderly man but can see it's a young woman, which again is why look. Why ever look? Similarly, when an officer learns a car has two or more registered owners, which, is not the case most of the time, the balance of circumstances may tip away from reasonable suspicion that one with a revoked license is driving, and so too the attributes of the car may be relevant. Consider if a car bears the making of peer-to-peer car sharing, or compare the likelihood that someone else other than the registered owner is driving a family minivan or a Ferrari. The officer himself may have a wealth of accumulated information about such matters, and the defendant may probe what knowledge suggests about the stop at issue. Such a challenge may also use statistical evidence, which is also daily extending and sophisticated should its scope. This is never actually going to happen. This is never going to happen because no one's going to ever be challenged it. But yeah, no, this is never going to happen. State municipalities that may often keep information about hit rates. In other words, the frequency. Why would they keep this information? Why do they keep statistics? Because the statistics are only going to hurt them. Why would they ever do that? Why would they keep information about hit rates? Because it can only hurt them. They have the right now. If they collect hit rate information, they can't get more right. It can only take away. So why would they ever do that? Somewhat less direct, but also useful, are state or local data about the average number of drivers for each registered automobile and the extent to which unlicensed persons continue to drive. Again, why would you ever gather these statistics? They can only hurt you. Here, too, defendants may question testifying officers about the information. Indeed, an officer may have his own hit rate, which, if low enough, could itself negate reasonable suspicion. Doubtful. In this strange case, contested on bare-bones stipulation, the record contains no evidence of these kinds. There is but a single simple fact. Police officers learned from a state database the car on the road belonged to a person with revoked license. Given that revocations in Kansas nearly always stem from serious or repeated violations, I agree with the court about the reasonableness of the inference. I'm having a really, really, really hard time finding a future Supreme Court splitting the difference on a revoked driver's license versus suspended driver's license. I suppose it's possible. They're leaving themselves open that door, but I'm not really seeing it. I'm not seeing a lot of courts taking advantage of that either, right? So this only dictates the results in a revoked license, not a suspended license. So again, a court could split the difference in a different fact, but why would they? I don't really see that happening. Then again, I didn't see this happening, so what are my predictions worth, I guess? That does not mean cases with more complete records will always wind up in the same place, but why would there be more complete records? A defendant like Glover may still be able to show his case is different. The presence of additional facts dispels the suspicion, which is to say that in more fully litigation cases, the license revocation alert does not end the inquiries, but the first is no doubt an important step in the reasonable suspicion. Okay, well, that was interesting from Ginsburg and Kagan. Okay, that's the thing that happened. Justice Sotomayor dissent. All right, Justice Sotomayor, tell us why the court got it wrong. At least my alcohol is tasty. I got that going for me. In upholding routine stops of vehicles whose owners have revoked license, the court ignores a key foundation of our reasonable suspicion jurisprudence and impermissibly and unnecessarily reduces the burden of proof. I therefore dissent. I begin with common ground. The Fourth Amendment permits brief investigatory stops on facts that do not constitute probable cause. To assess whether an officer has the requisite suspicion to seize a driver, past cases have considered the totality of circumstances, that is the whole picture, and analyze whether the officer has fact on fact and clue on clue. The stop at issue here rests only on one fact. The vehicle is owned by someone with a revoked license. The majority concludes, erroneously in my view, that seizing this vehicle, because again, every stop is a seizure within the meaning of the Fourth Amendment, right? So, seizure, this is a seizure, it counts. The seizing of the vehicle is constitutional on the record below because drivers with revoked licenses, as opposed to suspended license, which again, a court could differentiate based on that, but I don't really see that happening, in Kansas have already demonstrated disregard for law or are categorically unfit to drive. The analysis breaks down from settled doctrine and dramatically alters both the quantum, the amount, and nature of the evidence may rely upon. Marijuana is illegal federally, yes. Marijuana is a Schedule I narcotic under the Controlled Substances Act. The state bears the burden of justifying a seizure. This requires the government to articulate factors supporting its reasonable suspicion, usually through a trained agent. While the court has not dictated precisely what evidence the government must produce, it stressed an officer must at least articulate more than incoherent, an unparticularized suspicion or hunch. This articulation must include both facts and rational inferences. A logical gap as to one matter of this analysis may be overcome by strong showing or other indicia, but gaps may not go unfulfilled. Additionally, reasonable suspicion eschews judicial common sense. In favor of perspective and inferences, a reasonable officer viewing the facts through a lens of police experience and expertise. It is the reasonable officer's assessment, not the ordinary person or judge's, that matters. Finally, a stop must be individualized. That is based on suspicion this particular subject is being stopped or encountered on wrongdoing. I agree with that. That does not mean an officer must know the driver's identity, but the seizure must rest on more than the likelihood that a given person or a particular vehicle is engaged in wrongdoing. More than propensity, yes? You know? The inquiry ordinarily involves some observation or report about target behaviors, not merely the class to which he belongs. Faithful adherence to the precepts would yield a significantly different analysis and outcome. For starters, the majority flips the burden of proof. It permits Kansas police officers to effectuate roadside stops whenever they lack information negative to an inference that a vehicle is unlicensed by its driver. This has it backwards. It does, a little bit, yes. The state shoulders the burden to supply key inferences that tears the observation and suspicion. The majority repeatedly attributes such an inference to Meyer, but that is after the fact gloss on the 7-paragraph stipulation. Nowhere in his terse submission did Meyer indicate any informed belief about propensity of unlicensed drivers to operate, let alone they rely on such on a belief in seizing Glover. Marijuana is illegal under federal law. It's a Controlled One substance. It's a Schedule 1 substance under the Controlled Substances Act of federal law. It is illegal under federal law everywhere. States, as a matter of state law, have made it legal under their relative state law. But even in those states, it is illegal under federal law. It is a Schedule 1 drug under the Controlled Substances Act of federal law. Hemp, I believe, no, hemp isn't illegal. And it was, I believe it was recently re-regulated to make it a little less illegal, but it was never illegal. It was just a pain in the ass to grow before because it had different controls, but I think it's a little bit easier now. It was changed in the last couple of years. But hemp, I don't believe, hemp has never been illegal. It was never illegal to import. It was never illegal to grow, although again, it was a pain in the ass before a couple years ago because you had to basically prove it wasn't marijuana, so it was a pain in the ass. The consequence of majority approach is to absolve officers from any responsibility to investigate the officer's identity of the driver where feasible. That's what I'm saying, right? It's precisely what the officer ought to do and more capable of doing. Of course, some circumstances may not warrant an approaching car to take a closer look, but there are countless other instances which an officer has been able to ascertain the identity of a driver from a distance and make out their approximate age or gender. Indeed, our cases are rife with examples. Could they perceive more than just basic driver demographics? The majority underestimates officer capabilities, instead gives them free rein to stop a vehicle involved in no suspicion activity simply because it's registered to an unlicensed person. That stop is merely a guess or hunch. With no basis in the record to presume that unlicensed drivers routinely continue driving, the majority endeavors to fill in the gaps with its own common sense. But simply leaving an inference, common sense does not make it so, no matter how many times the majority repeats it. I think that's good stuff, yeah. Yeah. You might be right, Matt, but I'm not sure. I'm not going to look it up. Whenever the driver of the vehicle is most likely to be its unlicensed owner is by no means obvious. Like the concurrence, I doubt that our collective judicial common sense can answer the question. Even the Fourth Amendment jurisprudence allows us to do so. Contrary to majority claims, the reasonable suspicion inquiry does not accommodate the average person's intuition. Rather permits reliance on a particular kind of common sense that a reasonable officer developed through experiences in law enforcement. This approach acknowledges what may be common sense to a lay person may not be relevant or correct in law enforcement. Fair enough. This case presents the type of geographically localized inquiry in which an officer's inferences and deductions might well elude that of an untrained person, and would come in handy. By relying on judicial inferences instead, the majority promotes broad and flexible rules that overlook these regional differences. allowing judges to offer their own brand of common sense, where state proffered justifications for search come short and shift police work to the judiciary. Our states, including those of the majority sites, have looked to an officer's sensibilities to establish inferences about human behavior, even though they just as easily could have relied on inferences made by ordinary people. There's no reason to depart from that practice here. Finally, to bolster its conclusion as grounded in common experience, the majority cites empirical studies, but use of statistics illustrates the danger in relying on large-scale data to carry out what's supposed to be particularized. I agree with that too. It's a little bit hard to look at, you know, to look at big data to make an individualized inquiry, right? How did I get my analysis on this so wrong? How did I get my analysis on this so wrong? That's why I want to know. Yeah. The use of statistics, neither of the references reports tells the percentage of vehicle owners with revoked licenses in Kansas who continue to drive their cars. Their reports even offers a useful denominator. One lumps drivers with suspended and revoked licenses together, while another examines license status of only motorists involved in fatal collisions. The figures say nothing about how the behavior of revoked drivers measures up against the relative to their licensed counterparts. Whether one group is more likely to be involved in accidents, or whether the incidents are comparable, which would inform a trooper's inferences about driver identity. As the concurrence recognizes, while statistics may help, a defendant's challenge the reasonableness of the actions, they cannot substitute for the individualized suspicion. If courts do not scrutinize officers' observation or expertise, the seizures may be made on large-scale data alone, and I guarantee you they probably will. Data says nothing about this individual save for the class to which they belong. The analytical approach stays far away from acting upon observations of law, which the court has said is foremost method of enforcing traffic stops and vehicle safety regulations. The majority today has paved the road to finding a reasonable suspicion based on nothing more than demographic profile. Its logic has made the state's task all but automatic, and even more so automatic given the technology that currently exists, which I've been talking about for a little bit now. I've definitely seen many a cop car with cameras on them, and even more will be, and there's going to be alerts flashing and lights going on and so forth and so on, and once they're pulled over, I smell marijuana, I smell whatever, your eyes are glassy, come up with your own ready-made excuse. The majority justifications for this new approach have no foundation. It supposes that requiring officers to point to training material would demand scientific certainty. That's no truer in this case than other circumstances. I agree. Indeed, the state here was invited to stipulate the evidence it relied on could have easily described the individual or accumulated experience. The state chose not to present such evidence, and shown not shown accordingly has proved no harm. Yeah. In fact, it is the majority's approach that makes scant policy sense. The state need not set forward all the information officers considered before forming suspicion. What conceivable evidence could be used to mount an effective challenge, as the concurrence imagines? Yeah, the concurrence did seem a little fantastical to me. It seemed a little fantasy based, yes. What could meaningfully interrogate an officer's action when all the officers say is that it was registered an unlikely driver? Yeah, my car alerted me and I saw it and I decided to pull him over. Like, how do you cross-examine this? How would a driver counter the evidence? By stating that they were a different age or gender that insisting the officer could have easily discerned it? Why would they? And where would the key defendant make his argument as trial judge makes key inferences, or by the same token fails to make an inference that might well elude the untrained? Moreover, the majority's distinction between revocation and suspension may not hold up in our jurisdictions. I'm not even really sure it holds up here, to be really fair. They seem to be bearing a lot on the fact that Kansas revocations mean a whole bunch of things, but they're not really saying the Kansas suspensions aren't enough, right? So I don't know if this case comes out differently even in Kansas. You kind of hope it would, but it doesn't say that, and given the logic of it, I don't think it necessarily applies. With this precedent in place, I mean, I value precedent, and with this precedent in place, if you came to me with a suspension case, I'd probably look at this and just say, yeah, it's close enough, because like it is kind of close. As the degree to which it's close enough or not, and like, I don't even think this goes your way in Kansas necessarily. Where drivers with suspended license have demonstrated disregard is categorically unknown. In several states, the ground for revocation includes offenses unrelated to driving fitness, such as license to unlawfully buy alcohol. Yet other jurisdictions, revocation is a label assigned a temporary sanction, which may be imposed for infractions such as complying with child support. Whatever the majority's common sense assumptions is thus open to challenge. Vehicle stops interfere with freedom of movement, are inconvenient, and consume time. Worse still, they may create substantial anxiety through unsettling show of authority. Before subjecting motorists to this type of investigation, the state must possess articulable facts and officer inferences to form suspicion. State below left unexamined key components of the reasonable suspicion inquiry. In an effort to uphold the conviction, the court destroys the Fourth Amendment jurisprudence that requires suspension. I respectfully dissent. Well, that is the end of this case, so that was super, super exciting. Super, super excited. Well, I got that one massively wrong somehow. Thank you, Leonard. I'm glad to know that you love me. Even though I got the prediction wrong. You're a good friend, Leonard. You really are. You are a good friend, Leonard. I'm glad that you're my friend. Please don't move to Luxembourg. It will put you too far away from me. I got it right. They got it wrong. Fair enough. Yeah, I don't know what it says about a whole bunch of things because it's really interesting. It's really interesting like how you perceive yourself and like different things. Because I was watching John Oliver's segment. He did last week tonight about this One American Network, which he described as a far right network. And of course, Oliver himself is left leaning. But like I was listening to like the things the network were saying, and like it was funny to me because like I was agreeing with a lot of it. But then I read this and I'm like, I'm with Sotomayor. So am I left leaning or right leaning? It's like it's hard to tell, man. It's just a weird thing, man. Andy, I am honored. Thank you very much for opening a bar in your game called the Uncivil Law Bar. Yeah. You got Malibu dismissed with prejudice. Congratulations, Leonard. That is an accomplishment. Yeah. I'm right leaning, but I'm skeptical of state power. That's a fair point. Yeah. So yeah, that's a fair point. Yeah. All right. Well, that is the end of our stream. If you liked this stream, if you'd give it a like, I'd appreciate it. If you give me a super chat, I'd even appreciate it more. I will be your friend for money. Yeah. Yeah. You can't always bet 1,000. That's true. Can't always bet 1,000. If you go back to listen to my oral argument, I thought Sarah Carrigan, the woman who argued this, was great. Thank you, Nuvi, for the $2 super chat. Hi, how are you? It is very much appreciated. Oh, okay, all right. And I compiled my first YouTube ad today. Ooh, very exciting. So you may be seeing it depending on what channels you subscribe to. But it's not necessarily the best ad, but it is a ad. Leonard says, "Have a drink on me." Thank you. So, we are going to, well, not necessarily debut because you might have already gotten my ad. I'm gonna play it for you right now, so that you can enjoy my ad. You're already subscribed to me, Zach. So it doesn't. I'm not trying to get you. I'm trying to get other people to subscribe. So But we will. Hold on. I'm loading it. I'm loading it. Hold on. Loading it. Ready? All right. Okay, let's do this thing. All right, here we go, guys. Hello, everyone, and welcome to Uncivil Law. So they're mansplainers because they correctly explain the law. Is that what's going on? Am I mansplaining? I'm mansplaining to you, I guess, because you're wrong. The last entity I heard say that was God, when he said, I am that I am. So, super. And we are going to be reviewing this unicorn Christ. Courts do, in fact, take notice of reality. Anytime you're looking at any provision in the Constitution, pretty much, and you say it's not that complicated, I'd respectfully submit that you've missed the boat. Strict scrutiny applies. Whoa, strict scrutiny applies. Well, we're getting ballsy. Strict scrutiny. That's some bold language for the appeal court when they say it doesn't even plausibly apply. That's shutting you down hard right there, just in case you were looking for that extra oomph. Now, see, someone already thought of your idea and the court already rejected it, so you were on notice. Sucks to be you. Are you sure? Are you really sure? Are you really sure? Really? You sure? Okay. They mailed the court an itemized bill seeking payment of $46 quintillion. That's some masterclass shade. It's just like, that's really good shade. Half of what a good lawyer should do is telling the client to shut the hell up. So yeah, it was my first attempt at an ad. Doing a little compilation. I used some royalty-free music from YouTube as an undercut track. Why not? It was a first attempt to put together an ad. It's like a minute 20 best of compilation. And, I am now part of the problem, and I am now buying YouTube ads. So, that may show up in your YouTube ads. Yay. Yeah, it was free. It was free. It was royalty-free music from YouTube. It seemed okay. I listened to like a dozen songs, and it seemed the most okay. So I was like, yeah. I might change it. Ad brings in the money. Well, thank you, Haven. Yes. I'm trying to gain subscribers and shit like that. So I'm targeting all the law channels, right? Because you can in the ads, you can specify your demographics, right? So I'm like anyone in the United States between certain age ranges who happens to be and please run ads against these specific channels. Yeah. So, good times. We'll see what's going. Yeah, it's royalty free music. Yeah, it was reasonable. Someone gave me some money. I'm glad you enjoyed the ad. It was the first attempt at doing an ad. I'll make some other stuff. I'll put some other compilations together. Obviously, it's just the first one I've ever done, and we'll do some other stuff. But it was okay for a first attempt. $25 from New V, which do Defense Department versus 3M, so I can share it with other vets. I will do that. As you know, for my standard policy is for $20. I will review any opinion from any particular court. So assuming there is an opinion from a court in defense distributed, but isn't that case still going, movie? Because I've seen ads about it on stuff. And I'm happy to review any opinion. But otherwise I'll try to find some story about it. I'll cover a story about it, but I'll try to do that for you. Because of $25 super chat. For $20, I'll review any opinion in any U.S. court. Yeah, so good times. Yeah. Any opinion in any U.S. court. Is there an opinion in a U.S. court that's not in English? Am I a Redditor? Yes, I read Reddit. Yeah, I mean, there it was. It was okay. How much do adverts cost? You can select how much you want to run them for. I selected $4 a day, so that'd be $120 a month. So we'll see. Yeah, but you can say, you know, is a settlement? I'll see what I can find. I'll do something for you. I'll do something for you. Yeah. So I really, really appreciate the support, and thank you for giving me $49 worth of chat revenue because it means I can buy more ads. So you're giving me money to buy more ads to, yeah, okay, yeah, all right. Oh, that'd be good. Yeah, Matt, why don't you send me like the original complaint in that? Yeah, send me the original complaint. I'll cover that in lieu of a decision. So I'm not getting any Trump bucks, Adam. I make too much money. I'm not getting any Trump bucks. I make too much money. Very sad for me. All right. Well, thank you very much for the support as always. If you liked it, please like, subscribe. You know where to find me. We keep posting stories every day. Thank you to Matt, as always, for helping me edit. It really means a lot to me. It really helps me out. I really appreciate it. And until later, my friends, cheers and goodbye.